The Internal Affairs Doctrine is a choice of law rule. It holds that the law of the state of incorporation will govern the corporation's internal affairs. Hi, I'm Professor Seth Orenberg, and today we're going to look at the business organization's topic of the Internal Affairs Doctrine. Each U.S. state creates its own corporate law, and promoters can choose to incorporate in any state, regardless of where they're doing business. This creates a sort of market for corporate law, a unique dynamic that could be good or bad for shareholders, stakeholders, and society at large, depending on whether this market creates a race to the top or a race to the bottom. But instead of dealing with the policy here, let's focus on the doctrine and make sure we all understand what is the Internal Affairs Doctrine. Our learning objectives for today will be to describe the Internal Affairs Doctrine, to remember and identify which corporate actions constitute internal affairs, and to identify foreign corporations and understand the implications thereto. The Internal Affairs Doctrine holds that a corporation's internal affairs are governed by the law of the state in which it is incorporated. We know very clearly where a company is incorporated. We can look that up on the Secretary of State website. But what are internal affairs? Internal affairs include voting of shareholders, fiduciary duties of directors, procedures for corporate action, and other issues regarding the relationship between the corporation, its officers, directors, and shareholders. To simplify this even further, you might think of internal affairs as related to shareholder rights. Shareholders have three basic rights. They can vote for management, they can sue management when management has breached a fiduciary duty, and they can sell their shares if they're unhappy with how management is directing the corporation into the future. The Internal Affairs Doctrine deals with shareholders' rights to vote and shareholders' rights to sue directors because internal affairs govern how shareholders vote and what they can vote on, and it also governs the fiduciary duties of directors and therefore what they can be sued for breaching those fiduciary duties. Why do we have such a doctrine? It has at least three benefits. The first is uniformity. All corporations that are incorporated in the same state should have the same law applied to them. This also creates predictability. Over time, as precedent develops, corporations can get a better and better idea of how courts will rule when internal affairs are implicated. And last but not least, this provides private choice. Regardless of where you live, you get to choose the internal affairs of your corporation. And this provides ability of investors and shareholders to decide for themselves which is the best law for them. What then is a foreign corporation? Quite simply, a foreign corporation is one that does business in a state in which it is not incorporated. Let me give you an example. Westinghouse Electric Company is headquartered just outside of Pittsburgh in the state of Pennsylvania. In fact, it's a famous Pennsylvania company that's been around there for a very long time, and most Pittsburghers think of it as local. However, Westinghouse is actually incorporated in the state of Delaware. And therefore, although it does business in Pennsylvania, it is truly a foreign corporation in Pennsylvania. It's domiciled or domestic in Delaware. And so even though it has its principal place of business in Pennsylvania, the fact that it is incorporated in Delaware makes it a foreign corporation with regard to Pennsylvania. In conclusion, we learned three things in this lecture. First, the Internal Affairs Doctrine holds that a corporation's internal affairs are governed by the law of its state of incorporation. Second, internal affairs mainly involve shareholders' right to vote for and sue directors and officers. And third, a foreign corporation is a corporation that is doing business in a state other than its state of incorporation. Related concepts to the internal affairs doctrine include application of the internal affairs doctrine, most commonly illustrated through the famous case of McDermott Inc. v. Lewis, and exceptions to the internal affairs doctrine, such as the pseudo-foreign corporation statute found in California Section 2115, which purports to hold that corporations incorporated elsewhere, yet doing business in California, are subject to California's law. We'll deal with these subjects in other videos. Thanks for watching, and I hope this helped you understand the internal affairs doctrine.